question, like, to people are not taking it seriously yet. That's definitely the way it goes. I was monitoring the way that GDPR panned out, and yeah, 2 years after GDPR went live, most people were still not compliant. I think using the data to galvanize active action within your company is a good idea, even if it's just to mitigate your risks. So I think you really do need to take it seriously. I think you need to think about it and you need to apply it. Now, for two reasons. There's two different types of risks. There's penalties and there's reputational damage. So if you focus on fines and things like that, sure, there are reasons to watch about, especially if you're managing a lot of sensitive data. But primarily, it's going to be about reputation. And what I noticed I was living in Ireland for a couple of years, just during the time. So GDPR wasn't a thing yet, but it was coming, and there was a build up to GDPR, but they had data protection laws there already. And the biggest change, the biggest difference I saw when I arrived there in 2001, the biggest difference I noticed between them and South Africa. I was there from 2001 to 2010. So when I came back here in 2010, the biggest difference I noted was that South Africans were unaware of their rights as data subjects, whereas people in Ireland were completely aware, and they were demanding rights. They'd had this type of legislation, not quite GDPR, but very similar, that had this type of legislation for a number of years. And yeah, they were very active. It was conversations we had in the Computer Society. We were talking about the implications of using CCTV footage in court cases for employee disciplinary hearings. We were talking about the impact of collecting too much data. There was a lot of really sort of mature conversations, and people were definitely demanding the rights. I've been noticing since 2010, I've been noticing how South Africans are starting to get a grip, like they're starting to understand the reason for POPI, and they're starting to exercise those rights. So I've seen people having arguments about why they need to provide their ID number at the gate when they at the security checkpoint at a gate. I've seen people sort of saying, well, why are you collecting this information about me? Is the survey anonymous? Can I, there's a growing awareness. And the information regulator, I don't know if you know this, but they've been on a very active roadshow for the last 2 or 3 months, going around the country, doing pop-up stands everywhere to talk to the general public and to raise awareness of their right to privacy. So what's going to happen? I personally am definitely noticing all the times I receive direct marketing that I don't like, that I'm unhappy about, that I feel is intrusive, or where I feel like I wasn't given enough opportunity to opt in, and I wasn't given the opportunity to decide if I wanted it. So people will now have a voice, they have a way to complain. The regulator has made it very clear that they will take these complaints seriously, that they will be acting on complaints. And if, particularly industries and companies and impact on data subjects seems to be quite high, they're going to tackle those companies. Obviously, they're going to only be able to do what they can do, but when there's a data breach, they are going to investigate. So we have this concept when working on this with Howard, we came up with this concept of the riskiest risks. And if there's nothing else that you do between now and the 1st of July, understand your most risky risks. You can in that penalties and fines section. There. So your risky risks, man. You've got to have, so starting from the top, how you manage account numbers, that's got the biggest penalty in POPI. So if you are managing a lot of account numbers, you need to understand how you're doing it and making sure that you're not adversely affecting people's right to privacy, or the right to protect their account numbers. If you're managing children's information, definitely start looking at that. And if you're managing special personal information, definitely look at that. And then there's types of processing like credit reporting, automated processing, things like that. So the idea of the risky risks was to give you a heads up on the 10 million Rand fine doesn't belong to everything. It doesn't apply to everything. It applies to very specific situations. One of them is don't ignore the regulator. So that email address that you use to register to your information officer, which yes, you do have to do, that email address needs to be monitored, because if the information officer wants to get hold of you and they send out a notice to you, they expect you to reply. They expect you to acknowledge it. And if you don't, then you are in trouble. But then in terms of data processing, account numbers is your highest risk. So I think if you take a risk-based approach, you'll realize that this is an ongoing thing. So the 1st of July is not, I think the sky is not going to fall on the 1st of July, but I think there are going to be a few, the regulator is going to make an example of 1 or 2 organizations, and then I think everyone will start waking up and realizing that they do actually have some teeth. I would hope, though, that you don't need the regulator to give you a hiding to do this, because obviously the reason we have this is so that we can protect people's right to privacy for reasons that are unfair towards us, or create decisions that we have no insight into that actually impact on our lives. So there are real human rights issues attached to this. If you are horrified with the Facebook Cambridge Analytica documentary, just bear in mind that didn't come from absolute malice. That just came from being very clever with data. So there's that.
Caroline, one of the things that if you could add, that was the challenge we picked up yesterday on that prior authorization. So that's almost you want to get going now, so even before the 1st of July. And that was just to help Derek, if possible, where you'd want to really shift a leg to get that stuff going.
It's actually a hidden penalty in POPI. It's not actually, it's not technically a legal penalty, but it's definitely, I think, one of the biggest risks. And the reason that, besides account numbers, that 2 has got to do with needing prior authorization. And if you do need prior authorization and you have to apply to the regulator from the 1st of July, you have to stop the processing and wait for the regulator to come back to you. So if the type of processing that has to be stopped is your core business, or has got something to do with your, would affect your turnover, you're effectively looking at minimum 4 weeks of no processing. And if the regulator does come back to you within those 4 weeks, or when they come back to you, if they decide they want to investigate, they're allowed to take up to 13 weeks to do the investigation, and you have to stop processing during that time. So use this grace period. Christian, you were not on mute. Were you wanting to ask a question?
No, sorry, I just joined, so I didn't see I wasn't on mute. Sorry about that.
Sorry. Okay, so use this grace period. If you apply, you would only impact it by 1 extra week. We've got 3 weeks. So yeah, just use the time. Then, if I can move on, the other question was, let's talk about the scope of POPI. Does it apply to international organizations? If they are processing data, it does. So the scope of POPI is it's different to GDPR. GDPR scope is if you are processing the data of anyone who is resident in the EU or any of the countries that fall under GDPR. So if they're under GDPR, so the UK or the EU, and then if they are a citizen, and if you're actively marketing to them. But if POPI scope is slightly different. It's not focused on who the people are. It doesn't care who the people are. What it says is that if you are an organization in South Africa processing data, or if you are an international organization that has data being processed in South Africa, unless the data just passes through, you know what I mean? Like, if the data is just in transit, that's a different story. But when you're actually doing processing in South Africa, and that's bearing in mind that the definition of processing in POPI is very, very broad. Okay. Somebody asked me the other day, would an ISP count? And technically, yeah, there has been case law in the EU that said that ISPs are processing information. So it's quite broad. And you'll see in the guideline for registering the information officer, in the guideline they actually talk about who should be registered in the case where it is a group of companies. So yeah, definitely does count. The only time POPI doesn't apply is if you're not processing personal information, which is almost impossible because we all have employees. And the other way it's not applicable is when you are processing data that is not PI or is sufficiently anonymized or de-identified. And I know Howard has a lot to say about that, about how difficult that is. So then so that's the scope of POPI. Any more questions on that before I go on to staying compliant in the long run?
I want to find out, it's Naroshni. Can you hear me?
Hi, Naroshni.
Yes, we can.
I want to find out. So let's say you're looking at a hybrid cloud solution. How would you handle POPI if you are providing a customer solution or something where the data is going to reside in the cloud? I'm thinking that you should be looking at, where who's responsible for the cloud. So if you have, say, Oracle Germany or one of the other countries, how would you then handle the POPI Act in conjunction with the international equivalent acts?
Okay, I'll definitely answer that one. Has anybody got something similar? So something like that, like what do I do about an outsourced thing or a system running in the cloud? Does anyone else have questions like that?
Sorry, Caroline, it's Derek again. Just to go back to your previous point. So with POPI, is a private entity classed as, we're protecting personal information. So if there's a company that is just, going back to the question is, if they just deal with organizations, they don't deal with individual information, does POPI apply to them too? So I'll give you an example. They're a big manufacturer. They just manufacture, they've got a distribution network that don't distribute to an individual, but to organizations.
Sorry, just say that again. If it's a distribution, if it's what?
It's a manufacturer entity. It just manufactures goods, and then it does distribution to, through a distribution channel. So it's not directly to individuals. So they've got nothing to do with the individual, but they deal with organizations.
Yeah, so it's not Joe Public Retail. Okay. All right. So I'm going to come back now to the hybrid cloud question. I'm just going to finish off. So this is still relating to the scope of POPI, okay, about what types of organizations. So let me just clarify that. POPI applies.
Caroline, could I just Paul has asked a good question. So for example, if I'm using Power BI and I publish my reports to powerbi.com, is that also a information crossing borders and cloud?
Yeah, because the data ends up getting saved or hosted, or it ends up sleeping in another country. Yeah. Would you agree, Paul?
I agree, yeah.
Okay.
So I think I just wanted to bring all of these issues around cloud-based. So whether it's hosting applications, whether it's entering data, whether it's Power BI, anything where, as you said, if the data goes and rests in a server somewhere else, you've transferred the data across the border.
Just a quick question on that one. Is it also true in cases where there's a local server, for example, so if the server is in South Africa, actually, let's say it's not powerbi.com, but it is accessed from elsewhere in the world. Is that also information flowing crossing borders? Sounds like it does.
Yes, it is.
Okay, so even if it doesn't sleep there, it's being viewed there, and it can certainly be downloaded and processed and etc. Right? So it still constitutes border crossing borders.
It's not okay. So let me just clarify. All right. So I'm going to come back to the scope question later, but let's just talk about these cloud system situations. So what Howard was talking about there was cross-border transfers. Okay. And that's where the data literally flows over the border of South Africa. It doesn't matter if it does it via satellite or ocean cable or whatever it is, but it ends up on a server somewhere that isn't in South Africa. Okay. And that's a cross-border transfer. So that's data, personal information that you're dealing with in South Africa, and then you upload it to Dropbox, for example. So that cross-border transfers is something that privacy legislation is looking into quite closely. and manage. And it's ones that every end up having privacy legislation, and most of them do already, because one of the reasons we have this is so that we can manage data without infringing on the right to privacy. And obviously data processing is global, so it's not like every country is, sort of lives in a little box. So with the cross-border transfers, the time you want to really look at that, your big risk, if you look at the risky risks, cross-border transfers is when you're dealing with information about children and when you're dealing with special personal information, or SPI. SPI is of an Indian membership, political orientation, sex and health, sex, life and health, that sort of thing. And if you have data like that, so I'll give you a very simple example. If you've got data like that and you are storing it somewhere outside of South Africa, like in Salesforce or Dropbox or G Suite or whatever it might be, in Google or whatever, you as the responsible party, or basically one of your responsibilities under POPI is to know where that data is. And your responsibility is to check to make sure that the jurisdiction that applies to that stored data has got adequate privacy protections. All right, so this has got to do with other jurisdictions and do they have privacy protection. A lot of countries don't, and notably US doesn't. California, I think, is the only state that has like really rock solid privacy. But yeah, I mean, there's other laws in the states that do that's problematic. And just to preempt the question, no, we don't have a list of countries that are considered to have adequate protection. But what we do is at the moment, we're just using the list that GDPR has published as being, they have a list of what they call the third countries. And third countries are not considered to be adequate. So that's the deal with a cross-border transfer, right? Which is different to people accessing it. So if the data has been accessed, so if the data is being accessed from overseas, so if you have the data, you're storing it, you're hosting it in South Africa, and you've got a service provider, say maybe a software developer in India or some country, and they are pulling data down onto these, onto the machines to do development, or if somebody is reading that information, has it access like a portal where they log in and they have an account number and they're looking at the data. Sorry, the developer example is cross-border transfer. If I'm accessing the data, if I'm looking at it, it is coming to me. It's like it is available to me. The process is very. It doesn't mean you can change the data. It means that you can consult the data, or that you need to be aware of. If it's a supplier, if it's a third party, you need to be sure that you've got a good contract in place with them. You need to have your data processing agreement. With all your third parties, you need data processing agreements in place. Sorry, so without pictures, that's a bit difficult to explain, but it's just assume any kind of thing, the definition for process, and just understand exactly how broad that is. Are we okay with that? Howard, do you think I've covered that?
Yes, I do. I do think I think it has covered it. I think Paul may have some more internal questions. So, for example, if you're getting data from an external area or whatever it is, and then you start sharing across departments or groups, and that idea of your lineage and the purpose, what level of protection do you need to do within the organization?
Okay. I will answer that in a second. I want to just jump, if I may, just jump back to the other question around, just a quick one, around if we're a B2B manufacturing entity, we're doing distribution of goods and we don't really deal with PR.
Okay.
So if I could just deal with that one first, just to finish off the scope question. If with that, sorry, Raylene, what link are you looking for? I'll get to you in a minute. Maybe just let me know.
I'll focus on that. I'll try to help her.
What link? All right. So if you are a B2B organization, right? So you're manufacturing. What POPI definitely does still apply to you for sure. the only difference between you and say, Vodacom or Checkers is that you're not dealing with Joe Public, so their first level might be a lot lower. So you're not a data processing kind of organization, and so you might find that your little than someone who's, for example, day job is just to crunch data. But the point is even if okay, so there's two factors coming in here. POPI applies to personal information about natural living persons. It also applies, which is quite unique. It's not the same.
Sorry, am I the only one that's losing Caroline, or are we all suffering from that?
Same as GDPR. So I mentioned
I'm also having that issue.
Me too. Not hearing Caroline. No.
Sorry.
Sorry. All right. Hold on. Can you hear me now?
Yeah, we can. I think there was a really important thing about those legal entities, or you were talking about not where POPI is slightly different.
Do you have my POPI 101 slide deck there, Howard?
Sure. I don't think so.
I can share my screen if you like.
Okay.
Okay. So just to close that out, POPI applies to information about natural living natural living people and juristic people. Okay. Interestingly, it doesn't apply to deceased people. It applies to all organizations in South Africa. It doesn't matter what you are. It doesn't matter if you're a church or an organization or where you might entities outside South Africa process information in South Africa. It applies to both private and public sector. And it also applies to data going outside. Okay. The only time it doesn't apply is if a purely household or personal. So, if you're managing, if you've been, so like your personal WhatsApps, the information that you've got no POPI obligations for the way that you handle your personal contact list. Okay, there's nothing like that. It's not for personal activity. This is really about entities and managing information for a reason. We're a filing system of some sort. And it also doesn't apply to sufficiently de-identified information. But the trick there is that the data must be not re-identifiable, which is quite difficult. And then obviously it doesn't apply to journalism, art, judicial process, criminal prosecution, state security, the sort of usual suspects, right? So POPI doesn't apply there. So I hope that kind of answers your question. So in terms of the manufacturing, the example of the manufacturers, I was actually speaking to a manufacturer the other day. They do mining equipment, and their risk profile under POPI is pretty low. But they do deal with their employee data. They have a lot of staff on the floor. Sometimes they have a lot of temporary staff, and they're responsible for the data and the information of all those people. You also they will have information about other organizations, and POPI does apply to that information. So if there's sensitive or confidential information about organizations, it would apply to that. What I will say is POPI doesn't give us a lot of guidance around that. Yeah, I think you have to kind of use your imagination or just think about it from a confidentiality point of view. But yeah, I hope that answers the question around the scope and applicability. Yeah.
Yes, thanks, Caroline. It does.
Okay. So now let's talk about data across departments. If you're a large organization and you're dealing with a lot of personal information and you've got a lot of systems that are transferring information backwards and forwards. So this would often be larger financial institutions, medical organizations. Yeah, you can imagine. If you have, when a large part of POPI is accountability, and POPI sets the head of the organization as being ultimately in the example concept of having data stewards, and POPI definitely should and must and actually must borrow those concepts. Okay, so you'll probably really look at that. It's not like you have to reinvent the wheel. We're talking about data here. We're talking about information. So that accountability should be set. And then if you go through all of the conditions so let's talk about the accountability. If I'm responsible for the way that the data gets managed for credit applications, for example, if somebody else in my organization is going to start using that data, they really should consult with me. There's a thing in one of the responsibilities of the information officer is to do a thing called a personal information impact assessment. You will find this in the December 2018 regulations, or a PIA. And if you look this up in GDPR, it's called a PIA. It's a privacy impact assessment. And literally, guys, like, how when you have change controls for systems, when you have technical change control, and you'll implement a change control process, and you'll have a CAB, right? You'll have a change advisory board, and you'll log the changes, and you'll make sure that there's assessment criteria. And very often that would include things like security, right? So if you're going to make a big change to a system, you need to check that the security is not going to be compromised in some way. So a privacy impact assessment or personal information impact assessment is exactly the same. It's the same as a change impact assessment or a business impact assessment. But what you're looking for is, are we in any way going to contravene any of the privacy obligations? And what you want is, if other parts of the business are going to be making any changes, and remember, change in POPI is also a change to the way that you use the data. So it's actually quite a lot broader than a normal technical change control. Okay, and it could apply to things that don't go through a technical. It could apply to things that don't go through a technical change. It could just be like Howard has the example of a Power BI situation where somebody goes in and they maybe in the marketing, right? So they go and they buy a bunch of qualified sales leads, which you can buy off the internet, and they buy this from someone, they download this data, and then they combine it with their databases. That's kind of problematic in POPI. You want to know what you're doing there, and you really do want to do a privacy impact assessment before you start doing that stuff. And in the same way, if I'm going to go and start messing with, using the credit data, the credit controls information in some unique way, there should be some sort of control point. There should be some sort of agreement or protocol, or and when it comes to very sensitive information like children's information or special personal information, that stuff should definitely go through a privacy impact assessment before anyone uses it or changes the way it's being used. And there should be ownership assigned. You should have someone like a data owner or a business owner or a system owner who gets to sign off that change is okay. So that's quite a long-winded answer. I hope that answered the question.
Paul? Parental guidance? No, he's not.
Okay. So okay. Has anybody got questions around the personal information impact assessments? Because I feel like it's something that's sort of glossed over in POPI. It's like one of the requirements of the information officer, but it's actually sort of swallows up a whole bunch of bandwidth if you look at GDPR.
Is Andrew?
Karen, I got a question. I should have probably posted earlier to add on the list. But in terms of the POPI Act, we as data owners or holders of data, of personal data, have a responsibility to make sure it's correct and it's up to date. What is our approach in terms of being able to talk to third-party companies that are unknown to the data subject? So I'm saying, for example, if we had to approach, I don't know, Trudon or someone like that for a telephone book in order to be able to update the data that we do hold on somebody without getting consent from the data subject. Is that something we can legitimately do? Because I've been battling to get an answer, and it's something I've actually posed to a couple law firms as well, not got a kind of a clear response on the matter. Because theoretically, if we could get hold of the people, you could contact them into full consent, but if your data is either aged or it's not, then you are not able to do that. So in terms of our obligation under POPI, is that something we can do?
So what you're talking about is Section 12. Section 12 talks about And I don't know this off the top of my head in case you feel like I'm very impressive right now. I did just look that up. Section 12 talks about collection directly from the data subject, and what it says is the requirement is that you must collect data directly from the data subject. All right. So that's POPI always comes in with a bold statement, like a blanket statement. It sets the rule. So the general rule is you have to collect the data directly from the data subject, and then it gives a few exceptions. All right. So the exception are okay, or we've collected it from a source, or if the data subject themselves has made that data public. Okay. And if it's a child, then you have to be able to illustrate that there was consent from a supervising adult, like a competent person, representing the child. So children's information is always more difficult. Like you really want to put a red flag over any information about children. And they're basically saying you can only do that if the information from another source would not prejudice the legitimate interest of the data subject. So in other words, you're not using data that's actually going to create some harm or discomfort or embarrassment for them. So there's a whole bunch of things, and it goes into a list of reasons about why it might be necessary. For example, there's certain situations where it might be necessary to do it, or you have some sort of legal purpose behind it, or it's just not practical to not get it any other way. So that's just about the collection. Okay, so in general, from the data subject. Otherwise, make sure that you publicly available. But the one thing that happens, Howard, if you want to maybe just show the risks again.
Sure.
So something I want to point out to you is, regardless of how you collect the data, you still have to comply with the lawful processing. So Chapter 3 of POPI talks about all the conditions for lawful processing. I'm not saying awful, I'm saying lawful. Okay. Like that, lawful processing. So that's in Chapter 3. It's the 8 conditions, and you have to whether you've not. One is the risks. The next slide. So the table of all the different types of risk.
That one or this one?
No, sorry, that horrible table that I always apologize for. The spreadsheet had a long spreadsheet. The one you had at just now.
Okay, sorry.
So if you look towards the bottom, there's the 8 types. Oops, sorry, I just jumped off of it.
That one?
Okay. You keep jumping away from it. Go back to the other one. So if you look at the conditions for lawful processing, that one. Okay. You'll see that there's, for example, if you look at condition, you can see there in the list, right? Condition 1 is accountability, which I spoke about. Condition 2, processing limitation, purpose specification, further processing. So you're not allowed to use it for another purpose. The quality of the information must be good. The openness. So if I collect the data from a public source, I really should let the data subjects know that I've collected this data and this is my intention. Why I'm doing it. Like, you should be open. Like, I shouldn't be like hectically surprised because to find out that you've got lots of data about me. And then obviously security and everything else kicks in. So I think there's 2 things you were talking about. There was collection and and then how do I process it? And then you also, can you hear me now, Howard?
Yes, that was a lot better.
All right, cool. Howard, I'm just going to present a slide for everyone because I think we're touching on an important point there, because there were sort of 3 points in that. So if I could present.
All yours.
All right, here it is. I just want to point out that consent on the bottom right-hand side is one reason, one justification, your legal mandate for being allowed to collect the data at all.
Sorry, Caroline, are you presenting? Are we not seeing your screen, or I'm not?
Okay, let me try again. How's that?
Still not on my side. Anybody? Now we're getting there. We go. Thank you.
Right. Yes. Alrighty. So I also want to point out on the bottom right-hand side is consent. That's one of the justifications. It's the most difficult one. You can see the list of criteria. Consent is very difficult to manage, guys. If you're collecting that data for the purpose of direct marketing, you have got to get consent. So yeah, talk to your marketing department because they've probably got the most risky sort of processing for POPI. But the other three types of justification, if you can lean on the other three reasons, other three justifications instead of consent, then do that. So the first one is that you've got some sort of legal reason for doing it. The other one is that you've got a contract with the data subject. And the third one is that you have a legitimate interest. And then consent, POPI specifies times when you have got to get consent. So for example, collecting information about children or direct marketing. So there's particular instances where you do have to have consent. Okay, so that was just one other point that was sort of mentioned in that question. It was sort of a three-part question. Maybe that's why it feels confusing.
Caroline, sorry, it's me again. So are we saying that if we collect data, say for example, from LinkedIn, and we want to use that data for a marketing campaign, we need to get consent?
Oh gosh, especially for a marketing campaign, yeah. I mean, marketing campaigns, direct marketing to people, you really have to get their consent.
So we need to do a lot of marketing before the 1st of July.
Well, only if your reputation and your brand can handle it, I think.
Am I correct in terms of, that's an interesting question. Let's say you use the sales navigator within LinkedIn to market to them. Is that violation?
Oh, it's such a tough question. We've literally been looking at like deep research from friends in the law fraternity, and that's a very technical question.
I thought it was a business question.
I think, look, first of all, when it comes to things like LinkedIn, it's a platform where people go and you have privacy settings on that platform that allow you to decide, be in control, right, of what it is that people can and cannot do for you. Yeah. So that would be my first point, is that I'd say, respect people's privacy settings. I mean, and check your own. Make sure, by the way, just make sure that your privacy settings are actually locked down. But POPI is quite clear about if you're going to mark, one of the things that POPI is quite clear about is that if you're going to market to people, you have to get their opt-in. So in other words, people have to opt in to receiving marketing information from you. And it has to be about, there's a form in regulation, in the regulation, which you must get off the regulator's website. There's a thing called Form 4, which has to be used, and you may only approach people with a Form 4 sort of request once to say, we would like to promote stuff to you. Is that okay? You may approach them once. And if they don't respond, you assume that they're not opting in. You're not allowed to send that form more than once. It's quite strict.
Sorry, I've got another question. So, I mean, on LinkedIn, and I'm just using this as an example just to probably highlight. So you ask someone to connect with you, they connect with you, then you take that information and do marketing. You still need to get their permission.
Okay, so here's the thing. Okay, if I'm connecting with you, I mean, what are the reasons why we connect with each other on LinkedIn? If I say that I want to be connected with, okay, what are the purposes? Like, what am I actually agreeing to? Right? It's a networking site primarily.
Yes.
All right. So if I'm going to advertise and market things to people, technically, what you should be doing is when you connect with that person, technically, you should be saying, I'd like to promote stuff. Is that okay? And then I connect with you because you want to promote stuff. If I have a relationship with you, obviously it gets a little bit vaguer, but on the whole, if somebody's not your customer, customers are slightly different, but yeah, trust me guys, direct marketing is tough. Like it just, but the bottom line is, if you look at the riskiest risks, let me just see if I've got something here on direct marketing. If you look at the riskiest risks, direct marketing is not your biggest risk, right? But it's your most public-facing one, and it's got to do with your reputation. So, and also the definition of direct marketing is so broad. It's like, it applies, by the way, to also asking people for a donation of any kind. So it's promoting goods or services or any kind of donation. So you can't say, oh, well, it's for the good of humanity, therefore I'm allowed to spam you. No, it's you do have to get people's opt-in. So yeah, it's a tough one.
Caroline, if I was to, let's say, for example, on LinkedIn, you put a post, so you're not directly contacting anybody via a direct message, you're putting a post into the public platform. I'm assuming that doesn't have the same complications.
Yeah, it doesn't, based on what I've read recently.
Right.
There's a whole thing about what is a transaction. So it's my kind of perspective of it right now is that if I put something up there and you find it interesting and you interact with me, that's different. I'm not pushing this as a message to you. Yeah.
Okay.
Caroline?
Yeah.
Sometimes when you, if you're a service provider, when the customer or the subject has to apply, sometimes you have that little tick box that says, can my third parties or one of our associated stakeholders contact you, or can we share your information? Is that now something that should not be in your application forms?
No, absolutely. You must put that in. I mean, if you have any intention of doing something like that, you definitely want to get somebody's buy-in, somebody's opt-in to agree to that. Because you must remember, you're the custodian of my data. I'm the owner of my data, so I should make the final decision about whether or not it gets shared.
So if I had to be the customer and I tick that, it means then I have now agreed that you could share my details with another stakeholder.
Sorry, say that again.
I'm just looking at this. So if I was the customer, and let's say I was doing an application for your company, just that little tick, if I tick to say, you can share my information with the stakeholder, would there not be a restriction on what sort of information you could share with the stakeholder?
Yeah, absolutely. I'm going to look for a slide for you. Okay, I can't find it. All right. So what I'm going to say about consent. Consent has got to be specific, voluntary, and informed. Okay, so you can't have a blanket consent. You can't say, I'm going to share your data with anybody for any reason for all of time. It's got to be in relation to a particular purpose. It's got to be, very specific, and I have to be fully informed. So you have to explain to me. In GDPR, you actually have to tell me who you're going to share the data with. POPI doesn't quite say that, but you do need to. I mean, you need to think about this in terms of the relationship you want with these people. So, if you want to be if it's appropriate to be super open, then do that. If it's not, if it's going to be a bit risky, then obviously you want to be specific without giving away too much. But yeah, on the whole, consent has got to meet those three criteria, and voluntary means that I must make some sort of action. If I don't make I don't make a positive action to say yes, you have to assume the answer is no. So you can't pre-tick the box, right? The other thing I want to say about consent is that the burden of proof is on you. If you have my consent and I complain to the regulator and I say, look, you didn't have my consent and you shared my data and I suffered some consequence, the regulator is going to ask you to give the evidence that you had my consent to do that specific thing at that specific point in time. So consent is not a yes/no field. Consent is an audit trail. Does that make sense?
Yes, it does, Caroline.
Cool.
Sorry, Caroline, asking so many questions, but a while ago I heard that the consent doesn't apply to actual physical telephone calls. Is that incorrect? It applies to email marketing and applies to those kind of things, but actual physical calls, that's vague or doesn't apply to.
Yeah, I've also, well, I'll tell you what, it's not about whether consent applies or not. It's about whether that is direct marketing, that Section 69, does Section 69 apply? And because consent may well apply, if it's not direct marketing, regardless of, consent is not only for direct marketing, but I assume you're meaning in the context of direct marketing.
Yeah.
And the latest reading we've done on this is the indications are that a voice, not an automated telephone call, right? Automated telephone calls are specifically mentioned in POPI as being direct marketing, but just sort of a one-on-one phone call. Apparently, no, that's not direct marketing. Do you need consent? Well, that's a different story.
Okay, thank you.
Yeah, that's a different story. Okay. Aaron's asking, is this at some point, or is it a lifetime thing? No, it's at a point in time. It's Aaron, it's specific, okay? So unless the processing starts changing, if you're making changes to the processing, you would need to, I suppose, it's a purpose specification, right? So if you've got my consent for a particular reason, you need to swim in your lane. All right. If you decide to change the way you're going to use my data, you have to ask me again. Does that make sense? If consent applies, remember that's only one of the 4 justifications. Okay. So Andrew's writing a question here. How seriously do we need to take our obligation to ensure that personal information is complete, accurate, not misleading, and updated? I think you need to take it pretty seriously. The one thing there is, if you look at the risky risks list there, right, you'll see that information quality is condition number 5. Okay, that is risk type number 3. Risk type number 3 is civil liability. So there's no penalty or fine attached to that, but if I find that it's impacting me, I can complain. Right, I have the right to make sure that my data is correct. So you have to publish a POPI manual that tells me how to contact you to tell you that my data is wrong and that you need to correct it. You also need to be able to give me my data to, if I ask you what data you've got to be able to tell me. This has got to do with participation. And I say got to, there are caveats on that. There's times when you mustn't. So, participation is a big deal, like direct marketing. It's not straightforward. But yeah, you need to make every effort to make sure that data is correct.
And maybe just to add on that, and Andrew, maybe I'm reading more into it. You are fulfilling a credit reporting facility now. Accurate information is probably paramount within that, with respect to the judgment around that.
Yes, that's 100% correct.
Yeah.
And so it's a challenge that we're busy facing with is that, it's how long's a piece of string. So obviously we put a lot of measures in place to make sure that our data is complete and accurate. But to what extent is it enough? So we have been dealing with the regulator in terms of that regard, but it's been slow going.
And I would think that Andrew, I think it would be really helpful if you choose your dimensions of quality very well. So things like timeliness and those things and you almost say these are the 6 dimensions, 10 dimensions that we're reviewing it on, and this is what we find to be acceptable. And it may be helpful to you to build a quality expectation definition at a data quality dimension level and with your bands as to see where you are within that.
Yeah, so we do have that sort of stuff available internally. It's whether we want to share that with the regulator or not, or to what extent.
Yeah.
But I would just share that these are the steps that you are taking to ensure accuracy.
That's a good point.
Yeah, and I think good data management practices are definitely your friend in this respect.
Yeah.
And two things I just want to point out, Andrew. The Credit Bureau Association has a code of conduct published.
I'm very familiar with it. Yep.
I'm sure you are. I'm not. So I was kind of hoping that they would give you some sort of guidelines in there. But are you saying that isn't the case? They haven't given you adequate guidelines in the code of conduct?
Well, we have, but we provided input, except getting all the bureaus to be able to agree on something is also has its challenges.
Sure. What I would say, one way to do it's in order to think about it the way the regulator will think about it, the thing I was talking about earlier, the personal information impact assessment. Put the data subject in the middle of the thought process. So a personal information impact assessment or privacy impact assessment basically says, if you look at the person, what impact could this have? So you literally do a risk rating.
Yeah.
And you look at what impact could this have on this person if this data was incorrect.
Yeah.
And prioritize the data that way. So almost think about, and unfortunately in your world, just about everything has a massive impact. But for example, if you think about something like a residential address, if my residential address is reflected incorrectly in the credit bureaus, that will directly impact on my credit. That will impact on the FICA checks. You know what I mean?
Yes.
Yeah. So that potentially has quite serious consequences for me if that is not correct.
Yeah. So I mean, when we do measures, it's obviously with the data subject in mind to make sure our data is correct. It's just we could bankrupt the company with the sort of measures that we could take. You know, to get it to that point. So I mean, they do say, you know, take reasonable measures, but yeah, it's always, you know, deciding where that line is.
Yeah, unfortunately for you guys, you're bang in the spotlight. So reasonable for you is very different to reasonable for anyone else.
Yeah.
Yeah.
Yeah. Sorry, can't really help you there. I think make friends with the regulator.
Yeah, we try.
It may also be helpful, Andrew, and I'm just thinking about that in terms of working with the banks in terms of their KYC. And because I certainly know from experience in working with the banks that level of detail in terms of where do they live, what is almost their coordinates from a GPS point of view. And I know the challenges that they have with flats and things like that. So that may be helpful to, and I can certainly set something like that up for you to get them to share the level they go into to deal with the KYC requirements, which is know your customer.
Yeah, so a lot of the banks use our data for the KYC type stuff and use it for verification as well as for authentication. So we, yeah, a lot of our data is used in a lot of ways like that.
Extra information that they, and I mean, I was in a presentation with someone from the bank that focused on providing imaging facilities in terms of understanding where these people are. So that some of them seem to be going a lot further, well, unless you're doing that for them.
Well, yes, I mean, without getting sort of the details of stuff that's not appropriate to share on a public forum.
No, it's been recorded.
We do a lot of services and things in that regard, and there's a certain expectation that we can return, you know, perfect data every time, which has its challenges. But yeah, I mean, the internal debate is always to what lengths do we go to make sure somebody's data is correct.
Right. Okay.
Yeah, I suppose participation is going to be one of your biggest things. Mzangiza had his hand up briefly, and then Paul.
Z, are you there?
It looks like he's dropped off. Okay, let's go to Benzi.
Afternoon, everyone. So I have a question around, I think, statement number 72. So it is basically saying that personal information leaving the country, you should have a consent form. If I'm summarizing it correctly. So does this apply to let's say you have customer information that sits outside of the country? So does that mean you need to collate a consent form even for all customers, or it is when the POPI is effective, then you worry about the customers that you enroll then going forward? So then my question is, do we have to backdate to be compliant? Yeah, so that's one question I have. And then I'm forgetting my second question. I'll post it.
Okay.
Yeah. All right. So section 72, I was just looking it up. This is about, first of all, it applies to the responsible party. So if you are simply processing the information on behalf of someone else, it doesn't apply to you, right? This isn't your obligation. But as a responsible party, it's saying that basically if you're going to transfer, there's all sorts of checks and balances before you transfer information to a third party outside of South Africa. So, and again, it has a blanket statement that says you may not do it, and then it gives the reasons why you might be able to do it. So there are a list of reasons there, and I think, Benzi, it's the key thing is always, right, is try to not lean on consent first. Please try first, like in section C, it talks about if you have a contract, right? So if there's a contract that talks about it, so if you can cover it off in the contract with the data subject, that's all the better. But there are other things, like for example, the transfer is necessary for the conclusion of a performance of a contract that's in the interest of the data subject. So there's many reasons why you would need to do it, and that would be justifiable under POPI. That doesn't include consent. Okay, so just be very cautious, guys. Like anytime you hear someone saying you must get the consent of the data subject, really question that. All right, because there really are very few times in POPI where you have to have consent. If you're transferring, one thing I highlight, what do you want to highlight in terms of risks? If you look at risk type number 2, it talks about child information and special person information. If those types of data are being transferred to a third party, you really do need to check the jurisdiction. Otherwise, you have to get prior authorization. Okay, because then it doesn't matter if you've got consent or anything. It doesn't matter. You have to get prior authorization. So Benzi, I think try to find one of that list. There's a list of things under section 72, A, B, C, D, E. Try to find whether you maybe fit the bill on one of those requirements before you look at consent. Does that help?
Yes, it helps. And so if you already had a contract that exists with a particular customer, and you didn't have a clause that will say this information will be used outside, so then then I will assume it calls for amendments or what do you call them, addendums to the current contract that you might be having.
Yeah, it's one of the biggest exercises of privacy is to get your data processing agreements up to date to meet the requirements for privacy legislation. So yeah, you may well need a DPA unless there's something in the contract that already sort of alludes to it, or kind of, the main thing is, have you been open? Is the person aware that, has this really been agreed? Are they aware? But definitely get a lawyer before you start doing lots of work.
Okay. All right. Thank you.
You're welcome. Paul's patiently got his hand open.
Thank you. Yes, my arm is having a cramp. No, it's just because the conversation. So
quiet on us the last one.
Yes. I'm sorry. I'm home now. So, all right. So I'm just wondering about something, Caroline, that's sort of related to information that was gathered for a specific purpose, but then the aggregated data that was collected is then used for something else. And I want to use a specific example here because it's not so straightforward, I think. Let's say, for example, in the case of a telco who collects like call records and call data, right, from the customers, but because of the towers that's been placed all around, they can also do things like traffic patterns and stuff like that. So from a POPI perspective, are there any sort of dangers when something like that happens? And if so, what are the mitigations that needs to be put in place for things similar to what I described?
Okay, well, your first question is it personal information, right? Does POPI apply? Like that's the first checkpoint.
Yes.
The second checkpoint is it information about children, or those first two risks, like the children information or the special person information going to an unprotected jurisdiction. Just heads up about that one. But in terms of the processing, so if you look at condition number 4. Condition number 4 is about further processing. So condition 3 says you have got to have the purpose in mind when you collect the data, and you've got to be clear about that. Condition 4 says if you're going to use that data for some other purpose, you have to go back to the data subject. It's about, think about it this way, like if it's my data and you want to do something with it, I should really be in the driving seat. I should have some say in it. There are, by the way, some exceptions. Like if for example, it's for secret purposes, for example, there are exceptions specifically around finance or international organized criminal, like combating organized crime or something. There are some exceptions, but on the whole, you really should let me know what you're doing with my data. And
so,
yeah.
Now, what I want to ask is, generally, like with a telco, you will use the call data record to look at the originating call to maybe look at your usage at certain points, or to look at the bandwidth or whatever. So you're saying that when the customer, or when you sign a contract, you need to then state, please be aware that we will use your calling patterns to look at how frequently you call from certain points, so we know whether we have bandwidth or your data usage or something.
Again, I would recommend you get a lawyer before you go down that road, because it really does depend on why you're doing it. Your justification at that point could be that this is in order to provide a service to me, which is the contract that you've got for me. So your justification, you wouldn't need my consent necessarily, right? And you may very well have legitimate. Can you hear me still?
Yeah, I can.
Yes. Yeah, you're fading out a little bit, but you're still there. Okay,
so just in terms of that, but in terms of openness, if you think about the conditions, in terms of openness and transparency, the question there would be, do you need to identify? Well, first of all, do you need to identify me when you're busy doing that type of processing?
No. Yeah.
If you can de-identify the data, great, do that. But if you have to identify me, then some openness, probably not a bad idea. But like as I said, get a lawyer in there. Your risk there is civil liability, by the way, not penalty. So this is in the interest of the data subject. Things like that. Sometimes it's not.
I have a related question. So like if you look at a telco or a mobile provider, generally you'd have an order, but you only want your device to be shipped to the person. So you'd probably use a courier company. So before you actually, so when you're doing the contract, you probably need to say to the customer, please be advised, due to the current situation, we will have your device shipped to you. So we will be sharing your name and address. But you probably then have to have some kind of data protection act with the courier company so that you protect yourself and the customer.
Exactly, yeah, because all of the conditions apply to that relationship with the customer, because they are now processing that information.
Okay.
So, you know, you need to make sure that the security safeguards are in place and that you've got, you know, that they are clear with you, right? So if they've got the addresses and they have a data breach, are they mandated to tell you, under contract, do they have to tell you about it? That's part of your data processing agreements. But yeah, I think it is good to be open with people. And you know, one of the things, guys, that I want to say about this is definitely get a lawyer. Like, make sure that you are disclosing what you have to disclose, that you're not disclosing too much. But one of the things to think about is when you have a data breach one day, like hectically surprised to find out what data you've got, or are they going to feel like they could have they trust you? Are they going to feel like, yeah, but these guys are always upfront with me. They are clear about what they're doing and why they're doing it. So there's nothing weird going on here. Like, I feel like I can trust you. So kind of just think about that kind of weird sort of softness, that soft side of people's perception of you. I mean, it doesn't stand a chance anymore. Nobody trusts them anymore. It's so I don't know if that helps. That's what I would say.
Yeah, that's a useful construct. Just actually to think about it from a data breach point of view. Karen, I just want to sort of confirm something I heard you say there is in terms of de-identification. In my traffic pattern example, right? So the things that are being tracked there is actually more related to the device. But okay, it's very possible and quite easy to link a device back to a person and therefore to personal information. But if the analysis or the analytics, I should say, if it's done on data that's been de-identified, and let's say my data is in that data set, am I being non-compliant from my perspective?
Look, you can't be non-compliant because you're doing the processing. It's about whether or not you are satisfying, like whether or not you are maintaining the or protecting the rights of the data subject, or whether you're processing it according to the conditions. Whether you have the justification, you know what I mean. So it's not like the pure processing itself is good or bad.
Okay.
And Paul, maybe if I can add something there, and it is important in terms of those identifiers or those unique identifiers. Okay, so even though it's a phone and you could be linked to personal information, that's where you've got to be careful of that possibility of linking it and using it for another purpose. So as soon as I can, and there's examples in GDPR where people have used the lat long to find out information about linking who voted what, just about on GPS coordinates that uniquely identify where you live, because there's associated information. And when you start making use of that for different purposes and not for just providing a service or things like that, then you have to be careful of that and ask further questions.
Okay, yeah, that makes sense.
Can I address the question from Aaron about grandfathering? What happens to current non-compliance, or is there grandfather policy? So what I was told by a lawyer, very secondhand sort of information I got, is that in general laws don't apply retrospectively. So POPI came into effect on the 1st of July last year, and you can't be reasonably expected to comply with POPI in the processing you did prior to that. However, if you think about the nature of processing, it is a ongoing current activity. So if you collected the data at a point in time, but now you're busy processing it, you do need to comply with the 8 conditions. And you know what I mean? It's not like POPI is a bit weird like that, because you are busy processing. So even if it's backed up and archived and stuff like that, I mean, you're still processing it. So POPI says that if you
well, while we wait for her to get,
I think I dropped off there.
Yes, you did.
Caroline, you have to rewind 10 seconds.
Sorry.
Rewind 10 seconds, yeah.
All right. So I don't know how long ago 10 seconds was, but what I'm saying is POPI says, for example, you mustn't have data if you don't have a justification for it, right? So delete data if you don't need it anymore. So if you did collect data about me or you were using it for direct marketing and now you don't, so I think there's very little grandfathering that's going to help you. Okay. Unfortunately.
Paul, did you have a last question there? We almost at 1.5 hours. I know we could probably go on forever. Let's have one last question.
Howard, I'm not sure what to make of that comment. So firstly, you invite me to ask a question and then you warn me about the timing. So I'm gonna then say,
Paul, like an extra, we have a good question from Christian.
Good.
How does POPI affect clients that use Google Ads and Facebook remarketing?
Oh.
It's a very good question. there's a lot of research going on around, at what point is it direct marketing and what point isn't it direct marketing? So that's your number one question. Is it direct marketing? Your second question is, does Section 69 apply? And the third question is, so I actually had an interview with one of the leading media houses to ask this question, digital agency, and their reply to me was, well, Google and Facebook know all about privacy, so if they allow it, then I guess it must be okay. So I was like, well, that doesn't really sit with accountability. I think it's not. I literally don't know, Kristen. It's such a difficult one. I think we're going to have to wait to see if there's anything that comes out from the regulator or any cases that make this clearer for us. So, it is a difficult one.
Okay, Paul, your last question.
So something that's just on the advertising, guys. Howard, if I could just close with that.
Sure. Sure.
If you're profiling people and you're marketing to a profile, so like you've said, like I want all people over the age of 18 who live in Johannesburg who are, that's not targeting a specific purpose. So that is not a specific person. So that is not direct marketing from Section 69's point of view, right? And so you're not processing people's information at that point. Does that make sense? Because you're looking at a profile. Another Google requires you to state on your website policy to make use of cookies. Yeah, no, cookies, hey, that's another option. That's openness. That's notifications. That's basically like I'm taking your data and I'm storing it or I'm using it. I need to tell you that I'm doing it. And there's cookie law in GDPR, in EU. It's worth looking that up. There's a thing called the GDPR and the cookie law. Yeah, have a look for that. But definitely on that score is not. It's not even about consent. That's basically around openness. Just letting people know. Yeah, I think if you tell people you're doing analytics, not legal advice, but yeah. Am I connected? How am I still connected?
You are. All right. I think I think there's one more. Yeah. Okay. So Paul, have you got another question? I know you've been.
Yeah, I've got one more question for you, Howard, and that is, how do you feel about this softness about trying to be open all the time and so on? I would like to get your opinion on that.
I think you've got a hidden question and a hidden agenda. You're referring to the open source community and not me as personally being open, but I take it and I thank you for that.
Yeah. No, it was a really good session. Thanks, Caroline. Thanks, Howard. Appreciate it.
Thank you very much. All right, guys. Caroline, thank you so much for your time. I was a bit disappointed that I didn't get any data management questions.
Sorry, Howard, we're not at that level. Give us 2 or 3 months, Howard. We'll be there, I promise.
Okay, thank you. I feel better now. Oh, 1.5 hours for Caroline. Sorry, I put you under pressure.
Yeah, no, geez, I'm gonna go have a glass of wine now.
Yeah. Thanks, everybody. Thank you very much.
Thanks all. Thank you so much.
Guys.
Cheers.
Cheers.
Bye-bye.
Bye.
Bye-bye.